and thanks for the invitation to be here. You know, coming from the administration, formerly, being in the court's shadow, I don't know about that. I view that they're in our shadow. So, so the global IP state, the global state of IP, the answer is it's mixed. That's it. So I'll explain, I'll give the good and the bad, and if we have time, which we probably won't, you're free to ask questions. But let me just start with a fundamental issue that came up yesterday and that not all policymakers agree on. And that is the fact that innovation is inextricably linked to intellectual property. So when we hear folks talk about the great inventions they've come up with, people need to understand, and not everybody does, that that couldn't have happened in a free market society without a robust IP system. People understood that from the beginning of the United States. But let me take you back to 1893. In 1893, what happened? The World's Columbian Exposition in Chicago. Now imagine the sight. At the end of the 19th century, at the end of the first industrial revolution as the world was going on to the second industrial revolution, smoggy, dirty, rainy, freezing, pretty ugly Chicago. That's probably, yeah, I shouldn't say anything. 1893, we'll stick to that. At that time, a brand new white city was built. Almost 700 acres of land, 200 humongous new buildings, neo-Gothic style. And it was teeming with innovation. Millions of people came from around the world to see the latest discoveries. And it was a sight that was never seen before. Alexander Graham Bell was exhibiting his latest telephone. There was an electric kitchen, 1893, with a dishwasher. There were moving sidewalks, which is basically what we have in airports today. There was the Ferris wheel. Very importantly, there was Wrigley's gum introduced for the first time. And not to mention Pabst Blue Ribbon beer, which, as Mickey Minhas knows, it's still the beer of choice for those who don't want to spend more than 50 cents a can. Everybody was focused on innovation. But the star of the show was light. For the first time, the whole city was lit. There were color lights. Every walkway was lit. Every building had lights. There were searchlights up in the sky that could be seen at 60 miles away. But the point to all this is that what happened was that it was the beginning of the War of the Currents. The organizers put it up to bid. Who should electrify the World's Columbian Fair? Edison came forward with his DC lights. Westinghouse came forward with his AC circuitry. In the end, Westinghouse won, AC dominated, and to this day, we benefit from that technology. But how did it get to that point? Because as we all know, Westinghouse did not actually invent the light bulb or electricity or anything like that. Edison was the one who first invented the incandescent light bulb after lots and lots of effort. Edison was not shy about filing for patents or using them. Edison, until very recently, was the one individual with the most patents to their own individual name. Until just a few years ago, that record was not surpassed. And he was not shy about asserting his patents. He hounded Westinghouse. Westinghouse kept putting out product after product. Edison kept suing him. And in fact, Edison even sued Westinghouse for the installation that he did under contract to the World's Columbian Fair. It drove Westinghouse nuts, all these lawsuits. But what did it do? It forced Westinghouse to come up with new technology. And better technology. What if there was no patent system connected to that innovation? Number one, most likely, Edison would not have invented the light bulb in the first place. Edison was very entrepreneurial. He needed to make a profit. If there was no patent system, he would have still been brilliant. He would have gone on to do stuff that did not require lots of investment and time. Probably he would have started an internet company. Just kidding. Sorry, those of you from Silicon Valley. But let's assume that Edison would have invented the light bulb anyway. What would Westinghouse have done, the competitor, if Edison did not have patents? Most likely, like any good engineer, he would have appropriated that technology and improved it a little bit. It wouldn't have forced him to work with Nikola Tesla and come up with an entirely different system. What is really important to understand is the inextricable link between every innovation that folks talk about and the IP system that underlies it. There is no example in modern times of major innovation without the IP system. Unfortunately, policymakers in the United States and in Western Europe most of the time fail to see this link, and they believe that innovation just happens. It just miraculously happens. And those who are clever will get a patent afterwards to try to pull the ladder behind them and prevent others from accessing that innovation. There's a major failure of understanding. Now, most policymakers, if you ask them, they don't know the answer to most questions that you ask them, but they know the answer to this one. Do you want more innovation for your country or less innovation for your country? I'll venture to say that almost every, if not actually every policymaker will say, I want more innovation. But then if you ask them the next question, do you want a strong IP system or a weak IP system or no IP system at all? Many of them will say, first of all, what is an IP system? Second, they will say that most likely we don't need one because the innovation just happens. And the result of this is the current state of the IP system worldwide, especially in the West. And it's a state where there are relentless attacks on the strength of the IP system. So let me go through some of them. First, since we are here in Sweden, standard essential patents. For whatever reason, that's really inexplicable in logic. Policymakers believe that standard essential patents are different than other patents. The reality is, when you look at them, they're the same. They give the same rights. They have claims. They have a disclosure. They have the same term. But they don't believe that that's true. They think that they require special treatment. So we have some crazy proposals. For example, in Brussels, we have this idea of a rate-setting board. Why is there a need for a rate-setting board for these patents in particular that aren't already, unlike any other patents, they're already regulated to some extent by the SSO agreements? And do you know how I know for sure that it's a crazy idea? Well, first of all, it comes from government. But in addition, the proposal is to put a rate-setting board and an essentiality check board for patents at the European trademark office. For whatever reason. They think that the people who should check patents are to be housed at the trademark office. So that's only the beginning of the problems. But obviously, we know that every time you try to regulate private industry in the trade that is particular to that industry, mistakes get made. And if I had to guess, it would go in the wrong direction for patent owners. In the United States, the situation is not very different. In 2021, the Biden administration withdrew the 2019 CIP policy statement and put forward a 2021 proposal. Now, thankfully, that proposal has been withdrawn through, after heavy pressure, politically and publicly. But the people have not been withdrawn. The people that have proposed the 2021 policy are still there and primarily at the US Department of Justice. And the 2021 proposal first outlines what a reasonable licensor should do and what counts as reasonable activities by a reasonable licensor. The policy statement pretends to think that policymakers in government know better than the actual industry players. And then after that, if agreement cannot be reached, it proposes that before litigation, even though assuming that you go through the exchange of information that the policy statement proposes and you don't reach agreement, it says you must have private arbitration or dispute resolution before you file litigation and discuss with your opponent where, jointly, we should file this litigation. And then, after all that, if there is to be litigation, the policy statement says that it's rare the case, and they don't have an example that's viable, where an injunction should attach to friend-encumbered standard essential patents. So, we will see what happens. The policy statement has been withdrawn, but now the administration has called for yet another public consultation. There were hearings at the PTO last week or 2 weeks ago. There is requests for comment out there. We will see what comes out of this. Some think that it could be helpful. Some think that the government wants to help and potentially gather information so that they can negotiate or argue with the European rate-setting board idea. What I say to this is what Ronald Reagan said. The most frightening words in the English language are, I am from the government and I'm here to help. In the pharmaceutical world, we have seen tremendous pressure on patents. First of all, there was the waiver that we discussed yesterday briefly of patent rights worldwide with respect to COVID-19 vaccines. Now, this year, they're discussing whether they should waive IP rights for diagnostics and therapeutics when it comes to COVID-19. Think about this. If you're a pharmaceutical company and you're working on therapeutics, and by the way, it would be really nice to have more therapeutics for COVID. The tests are nice, they work sometimes, but after I get COVID, it would be nice to take a pill and get rid of it. And if you're a pharmaceutical that's investing millions, hundreds of millions, and by the way, on average, $2 billion to bring a drug to market, if you know ahead of time that your patent will be waived, if you're successful after this huge investment, are you really going to invest that money to come up with a new therapeutic or diagnostic? Again, the problem is that they think companies will do that anyway, and patents are obtained only afterwards as an add-on. So we will see what governments do on therapeutics and diagnostics. So far, the United States has been opposed, or at least neutral. And as you probably know, at the WTO, where these discussions take place, the only thing that can be done is by consensus. Every country needs to agree, every country. Otherwise, it doesn't pass. So it's not an easy lift. But, if the United States and European countries and China and some other major powers agree, then things can happen. But hopefully, it will not. If it does, the next thing to worry about are other types of life-saving, critically technologies that are deemed to be critically important to life and human well-being. Climate change is a very good example, and the Director General of the WTO already said, after the waiver of COVID-19 vaccines, that there are other really important areas where the world should consider waiving patents. Also in the pharmaceutical world, there is huge pressure on drug pricing in the United States anyway. And because everybody wants lower drug prices, they're searching for ideas of how to remedy drug prices. And the easiest thing for many politicians is, let's break patents. And there's huge pressure on patents in the drug world. And it comes together with talk about evergreening and thicketing and the like. By the way, when somebody says, they would ask me, when I was the director, hey, director, do you think patent thickets are bad? What should we do about patent thickets? I would say, do you think innovation thickets are bad? Do you want a lot of innovation or less innovation? You tell me, and then I'll tell you if we want patent thickets or not, because they are inextricably linked. They want to use march-in rights in the United States. Folks probably know that there is, under the Bayh-Dole Agreement, Bayh-Dole statute, university and federally funded labs have broad rights to own the patents that result from that technology. But for national emergencies and special circumstances, you could march in, the government could march in and appropriate those patents. Now they want to use it, or there's a proposal to use it, to lower drug pricing, something that was never intended to be done. I hope folks see that there is a relationship here. The patent world is often fragmented between technology and pharma. The reality is that it's the same attack in a different flavor. And you will see a lot of tech companies, large companies from the west coast of the United States that all of a sudden are interested in drug prices. And you wonder, why is it that they think that certain patent laws should be changed to lower drug pricing? And the reason is that it affects everything once you attack patents in one area. It affects all the areas. In the administration, multiple attacks at the US Patent Office continue with respect to patents. We have, as you all know, post-grant proceedings, IPRs at the USPTO. And in the older days, there used to be multiple IPRs per patent. That has been reduced lately. However, there is still, in addition to an IPR at the PTO, there is litigation in district court, and it's still very difficult to pick only one or the other. Very often, still, there are multiple attacks in the court and the PTO on the same patent. In other areas, you've heard earlier today about diversity. This is a problem for the IP system. And by the way, everything I'm saying so far might sound negative if you're a pessimist, but we'll get to the good parts in a minute. It's really important to pay attention to what was said earlier today about diversity of innovation. A lot of people talk about diversity nowadays. In our field, it makes a huge difference, especially in the West, we are working on innovation with one hand tied behind our backs. Frankly, we're working with one hand and 4 fingers tied behind our backs. As you've heard Anne mention earlier today, and as well the panel, only 12 or 13% of inventors named on US patents are women. But here is the most interesting part. It is half the rate of women already in the jobs. Across companies, across industries, across countries in the West, the statistic is basically the same. So if you have 25% women engineers, you're going to have approximately 12, 13% women inventors. If you have 30%, you're going to have about 15%, and so on. And you saw that manifested remarkably in the stats shown by Volvo and Spotify. I'll bet it's true almost across the board. And that is remarkable, because these are women who have already gotten the degrees, so they've overcome those challenges. They are hired by the company, they're in the seat, and they are still innovating as evidenced by appearances on patents at half the rate of their male counterparts. That is low-hanging fruit that companies can immediately take action on. They have these people here on their premises in companies around the world. And it's true across industries too. Same in pharma, same at universities, same gap, 50%. When it comes to minorities, and I'll speak for the United States, the numbers are even lower. Only 7 or 8% of inventors named on patents are people of color. And it's not just patents. Venture capital. Venture capital dollars that went to all women firms, all women startups, last year was 2 to 3%. 2 to 3%. And mixed teams, men and women, only 17%. So that means that more than 80% of venture capital dollars went to all male teams, again, in the United States. We cannot compete globally in the technologies of the future if those are the statistics and it stays that way. And finally, in the crazy idea bucket, Senator Sanders, by the way, automatically when you say crazy idea, it's you sort of know what who the proponent is, has pushed, and quite successfully, a bill for the government to study whether patents should be eliminated altogether in pharmaceuticals, altogether, in lieu of prizes, to replace the patent system with a prize system. Something that has been tried for a long time and many years in the past, and it has in various places around the world, and it has failed every single time. This bill could pass, by the way, in the United States, because it's likely to be attached to a must-pass defense authorization bill. This is the way the United States works. You have a patent bill attached to a national defense authorization bill. So it could pass. Thankfully, it's only a request for a study, and it won't go any further. All of this comes from a lack of understanding that innovation cannot happen without an IP system. And unfortunately, this is not the time to experiment with any of these issues. We are in a critical race for the technologies of the future. The world is moving at an unbelievably fast pace, and we need all hands on deck. Now, I am quite optimistic, though, after all that. The narrative is changing. There are multiple bills proposed in the United States that would cause major patent reform. There is a bill, bipartisan bill, introduced by Senators Tillis and Coons on patent eligibility, reforming Section 101. It's been introduced already. There are likely to be hearings this fall. There's the Prevail Act, introduced by Senators Coons and Tillis, as well as Durbin and Hirono. And there's a counter bill in the House to fix the post-grant proceedings, the AIA, and actually return the patent system to what it's, the post-grant proceeding to what it was meant to be, an alternative to district court litigation, not an add-on, so you eliminate the multiple attacks on a patent. And there is talk about a bill to restore the right of an injunction after the litigation if the patent has been found to be valid and infringed. We did pass, by the way, as part of the Trademark Modernization Act, a bill that overruled eBay, the eBay case, and restored injunctions for trademarks. And it would be good to do the same thing for patents, and I think there will be a bill introduced on that as well. So I am optimistic, and I am very optimistic, mostly, about innovation. I'm optimistic that companies like Ericsson, since we are here, and many others around the world, understand that you cannot have innovation without a robust IP system. And since we are at Ericsson, let me mention Jaap Hartsen, who some people here, I can hear the giggles, know, is the inventor of Bluetooth technology. He's a wireless communication expert. He chaired the critical committee and helped to standardize the Bluetooth technology. He's born in the Netherlands, but did his work here at Ericsson in Sweden. And in 2015, he was inducted in the National Inventors Hall of Fame for patent 6590928, which I think still belongs to Ericsson. It's folks like this who understand that that innovation could not have happened without that patent and many others like it. And most recently, Emmanuelle Charpentier, who also did her work here in Sweden, even though I believe she's from France, and came up with CRISPR technology, a particular version of it, and won the Nobel Prize. With Jennifer Doudna, they were the first all-female team to win the Nobel Prize, and they are about to be inducted in the National Inventors Hall of Fame just in a couple of months from now. She got the Nobel Prize, but as far as I'm concerned, the much more important part of her credentials is that she has 50 patents to her name. As long as people understand that none of this can happen without a robust patent system, and I think more and more people understand. Conferences like this help. All of you going out and speaking about it. As long as there's that common understanding, I think the future of innovation is really bright. And the unbelievable change that we have seen and growth in technology that we've seen in our lifetimes and before pales in comparison to what we are about to see. And I'm very excited to see 6G technology that was mentioned yesterday by 2030 and beyond, but none of it will happen without a robust patent system. And I see lights flashing. Thank you very much. Great talking to you. I don't know, Bo, if we have time for a question, but
Andrei, you came all the way here to Sweden. We have time for a question. Who has a question for Andrei?
Okay.
Let Anna have it. Yeah.
So I was about to call on people.
So you mentioned, I'm Anna from Topsu, Anna Eugenio. So you mentioned that, and I totally agree, that the IP system has to be reinforced instead of weakened, and that the next kind of victim of the patent waiver could be the green energy or climate change energy technology. So I've been thinking about that kind of dilemma lately, and there is this, target for decarbonization that we all have to accomplish until 2030 or something. But each company cannot really do it by themselves. So this could justify some kind of committee, some kind of agreement between companies, between market leaders, influencers. But one of the things that I thought about, okay, maybe we could agree and make decisions together, and one of the decisions could be some kind of pact of non-aggression. So, but how could we, enforce our patents still and be motivated to have our patents without? So we would still have the right to enforce them. But do you believe that there could be some mid-ground where we could agree to all make decisions together in order to reach this goal as a team?
Yeah. Well, first you have to be careful of antitrust issues, number one. But there are examples like this, right? The standards world is an example of that, where you have standard-setting organizations and they have standard-setting agreements. Look how well it's worked. And there are pools out there. There are ways of doing this. What's really important, though, is to have those patents. I think it's very difficult to collaborate, even if you want to. If you get past the antitrust stuff and you want to collaborate and work as teams, really difficult to do that and exchange ideas if you're afraid that your competitor is just going to immediately take it at that point. So you have to have a robust patent system there. And I do think that there are examples where you got to be, again, very careful and mindful of antitrust authorities and laws in the various jurisdictions. But there are ways to make sure that everybody works together towards the common good, which is, by the way, regulated by government and imposed by governments, so there are reasons to have common solutions.
But even the regulations, as you said, would be different, so there's also the need to align on those, right, between governments.
That's an entirely different dimension. Yeah. You first have to do that.
So what would you see first? I mean, would it be more effective for the initiative to come from the private sector to push the government, or the other way around? Your personal view.
My personal view is always that it's better to come from industry if you want to be masters of your own domain, because you have no idea what's going to come from government. So.